When I tabled the first Hear Her Voice report, I made a commitment to victim survivors that the government heard them and was acting, and I am proud that we continue to act. I commend the bill to the House.
Before calling the next speaker, I'll just remind members on a warning to the lunch break. The other members for Clayfield, Broadwater, Capalaba, Kawana, Mudgeeraba, Everton, Glasshouse, Nanango, Southern Downs, Bundaberg, Toowoomba South, Cairns, Mount Omni, Burleigh, he should be okay, Currumbin, Buderim, Moggle, Gympie and Whitsunday. I call the member for Whitsunday.
Thank you, Mr Acting Speaker. Today I contribute to the Domestic and Family Violence Protection, Combating Coercive Control and Other Legislation Amendment Bill 2022, amendments that have been long awaited for many and sadly far too many who have to live with domestic and family violence. The diverse range of women, men and children that domestic and family violence impacts: First Nations women, professional women, women from culturally and linguistically diverse backgrounds, women with disability, women with different sexual preference or orientation, women every day carrying out their lives, Mr Acting Speaker, women like me, women like other women in this House. In 2021-22, the Queensland Police Service recorded 139,000 domestic and family violence occurrences. Research tells us that up to 80% of DV at times is not reported. This is particularly relevant to violence that is non-physical, social, financial and psychological. Terms like gaslighting, which is a form of psychological manipulation in which has perpetrators manipulate their victim by placing self-doubt in their mind. I'm all too aware that there are many people that understand domestic violence firsthand in such a way that they can't explain because it's part of their normal everyday life. There are also many who can't share their story or their experience. Sadly, too many across our state who have lost their lives as a result of domestic and family violence. As we all witnessed, one family who channelled their grief and their loss to become Queensland's most visible advocates of coercive control, and that is the Clark family. Domestic and family violence that took their daughter, their grandchildren, and their own daughter, who did not know what coercive control was. In fact, Hannah did not recognise the behaviours of her then husband and was in fact, by nature, the definition of coercive control. And when I speak with members of the legal fraternity, Mr Acting Speaker, it is all too common, unfortunately, that women and victims of domestic and family violence do not understand what coercive control is. While this bill aims to address the recommendations from the Women's Safety and Justice Task Force and the need to review the specific offence, this bill contributes to expanded definitions that will support further legislation to be introduced as part of a further trench of reforms as a standalone new offence of coercive control, which we understand the government will introduce as part of the reform agenda. The LNP will not be opposing and in fact will be supporting these amendments today. Amendments to the criminal code that rename and modernise and strengthen the offence of unlawful stalking to unlawful stalking, intimidation, harassment or abuse. I note the committee's recommendations. I also note the Chair's personal views that instances of DV, in his opinion, had not increased, but the willingness of those aggrieved to come forward has grown. I agree. The willingness of victims of domestic and family violence, when they have a greater awareness of what it is, do come forward. But I speak to police officers, to teachers, to health professionals, to services across the state, where I only hear comments that cases are increasing. As cost of living pressures, housing crisis, societal issues of drug and alcohol abuse, violent pornography that can now be accessed by children of all ages and adults is more widespread than any generation faced before. There is evidence that violence is not only increasing, but the occurrences of more violence, both physical, psychological and emotional and more complex, is in fact increasing. The history of domestic and family violence, The degradation of women and children in their own homes in Queensland is shameful. For too long, this has happened behind closed doors. For too long, serious abuse was belittled as being another domestic. For too long, victims have spoken up only to be silenced. And for too long, we have said enough is enough. The Premier herself has said the time is right for action, except one thing. She said that on the 18th of August 2015, Mr Deputy Speaker. She has been in power for that long, and what have we achieved as a state? Countless reports, yet no evaluation of any measures that have yet to be enacted. This is an issue that we want to work with the government on. I think we all agree we want to see women and children protected from this insidious violence, but we won't stand by while we will support amendments. It is also our job to call out when the government continues with words and very little action. The Queensland Audit Office report, Keeping People Safe from Domestic and Family Violence, was nothing short of damning, as it reminds us all when we talk about this system and services, the outcomes of ineffectiveness is sometimes tragic, resulting in tragic situations and circumstances. It's important to reflect on this report as we come and debate this legislation, because it is essential to ensure the changes before us are monitored and that they work. We know too well that the stakes are high if they don't. The legal fraternity, police, services in the sector are all very concerned that the need for education and funding is enormous. In particular, the need to engage and consult further with both services that support our Indigenous and cultural communities is critical. We already have an overrepresentation of Indigenous women who are named as who are currently dealing with domestic and family violence. This has been raised directly with me by organisations like the Bengal Foundation, as well as Indigenous leaders in far north Queensland. The Audit Office found a lack of evaluation of domestic and family violence initiatives, to the point that the department even stopped collecting expenditure data in 2019. So the department doesn't know how much it's been spending on domestic and family violence initiatives since 2019. I'll repeat, the department doesn't even know how much it's been spending on initiatives to prevent and educate domestic and family violence across our state. What they did find is that prior to that, only 4% had been spent on prevention measures. This is very concerning, Mr Deputy Speaker. This is very concerning when we want to see and witness a societal change, when we want to introduce further reform, when we want to enhance laws and give police powers, give the judiciary further powers, when we, and I say we as a collective, need to do a whole lot more. But when the government is only allocating 4% on prevention measures of education, of perpetrator programs, that is disturbing. This, coupled with other findings, that the department does not know the use, detail or outcomes of the RESPECT program, as a result has no idea whether the program has been effective or whether it is even a useful resource, that the department doesn't track perpetrator programs, that the government does not collect data on attendance rates, on completion rates, on waiting lists for perpetrator rehab programs. It also doesn't know how many perpetrators reoffend after they've completed rehabilitation programs. Queensland's corrective services can't confirm how many domestic family violence perpetrators have been in Queensland's prisons and have no permanent programs for rehabilitating domestic family violence perpetrators in Queensland prisons. The department has not reviewed the placement of high-risk teams since 2016. It does not analyse data to determine which local government areas are most in need. Some areas with the greatest high DV rates in the state don't have high-risk teams. Once again, the lack of police training was pointed out, especially for those assigned to specialist DV roles. And finally, the introduction of choking, suffocation or strangulation in a domestic violence setting as a specific offence in 2016, following the not now, not ever recommendation, has been measured has not been measured as to how effective it has been in preventing subsequent violence, and to date the Queensland Police Service has had low conviction rates for this offence. It is the single biggest reform that is required, Mr Deputy Speaker, and that should be a priority for this government. I received a phone call today, Mr Deputy Speaker, from a lawyer who is acting for a woman with domestic and family violence as part of her life, and they have little confidence in the current law as it stands. Mr Speaker, I raise these points because, as you can see from the final one, it is vital that when we introduce measures, when this House makes decisions to reform and to change definitions, that we must monitor them to ensure that they work and are effective. It cannot be that we bring these in and an announcement is made and then walk away, and that has happened time and time again. Some of these measures will work, and I hope they do, but some may not. Some may put the onus even more pressure on the victim. Some may have unintended consequences. These need to be identified, they need to be reformed in a timely way to ensure that we do have the best legislation and measures in place to do what we can to protect victims. As I said, Mr Deputy Speaker, the LNP will be supporting these amendments today, but we want to see a system that recognises the gendered nature of domestic violence, that doesn't put all the burden on the victim, but works to prevent and rehabilitate perpetrators, and in particular, early intervention, all leading to a safer Queensland. On the specifics of these measures, there are several that I would like to make comment on. Firstly, on the modernisation of the sexual offence terminology. I understand many stakeholders, and I note the Attorney-General addressed this as well, hold concerns over the choices of terms in modernising this. I too share their concerns, as I'm sure many in this House. The idea of modernising this language is to stop sanitising the gravity of the offence. Adults do not have sexual relationships with children. Any kind of sexual relationship an adult has with a child is child abuse. I would have loved to have seen the word abuse in the title of the offence. However, I too understand the need to ensure that every chance of a successful conviction is not put at risk by changes in terminology that would have an impact and unintended consequence for victims. While conduct does not grasp the gravity of the abuse, it does take a step away from the word relationship. The changes to carnal knowledge are clearly piecemeal and rushed. We need wholesale changes to this section of legislation to give clarity to sexual offences with children. I understand the legal history in Queensland, but for victims and for modernisation, there needs to be greater reform explored. The importance of evaluating measures will be particularly important for the cross-application changes. We know many victims are misidentified as the perpetrator, particularly from First Nations background. While we support this measure, it must be tightly monitored to ensure we are not further traumatising victims through misidentification. I hold similar concerns for the resourcing of legal aid with the expansion of the class of protected witnesses. In Hear Her Voice, systems abuse was well documented, where you have a perpetrator who is unrepresented in court, who is further exerting control over a victim through cross-examination. It needs to be ruled out. However, given the lack of data on this, I am concerned that Legal Aid Queensland will have to wait until the problem appears before it will get assistance from the government. While I note the Attorney's announcement of further funding, certainly Women's Legal Services have also expressed the concerns that they have about the strain it will put on their services, where they already are not able to answer and respond to 30% of inquiries. We know this will put additional strain on the system, but if it leads to further delays, it will create more trauma and, in fact, potentially be a deterrent for victims to come forward. So we certainly call on the government to monitor and ensure that no gaps are left. There will also need to be additional resources for police. As we see, any expansion of definitions leads to an increase in need for resources to respond to it. A call for change was a sobering read. We know the majority of police are out there doing the right thing to protect and serve our community. It is concerning, though, Mr Deputy Speaker, when we ask questions of the police minister of full-time equivalent resources that we currently have, of recruitment numbers that are not going in the right direction, and we introduce reform as big as what is coming with coercive control, that our already under pressure police resources will not be helped with this situation. However, the police force, without a doubt, also raised in the report and to the committee that the Queensland Police Union also stated that they envisaged they would need 500 more officers with the rollout of reforms. We certainly need to support them, as this task will be large. This responsibility lies at the feet of the Police Minister, without a doubt, but upon all of us when we're speaking locally with our local services. Mr Speaker, as I said before, the LNP will support the amendments of the bill, but it means nothing if there is no follow-through. We call on the government to ensure that genuine action, genuine resourcing and genuine education is carried out, that they plan, deliver and evaluate so that we can ensure a safer Queensland for women and children. Mr Deputy Speaker, we raised questions, and I would like the attorney, if possible, to address the implementation officer that was made, that the Hear Her Voice recommendations outlined, the need for an implementation supervisor. There was an announcement late last year, Mr Deputy Speaker, that an interim acting role had been appointed. Certainly we would like clarification that a permanent appointment has been made, because this tranche of reform and that is to come will need that resource to ensure that it is carried out. Mr Deputy Speaker, this was raised by victims who have grave concerns as we look to the additional stages of reform with coercive control. The proof beyond a reasonable doubt is already challenging enough in the system when there is physical abuse, and at times horrendous physical abuse. There are real concerns that existing domestic violence legislation already addresses coercive control, and in fact that has been very, very challenging for police to prosecute. We've seen that already through the strangulation laws, but without a doubt, what is raised by many across the state is that victims, if this reform is not properly handled, that victims will be the ones that pay the ultimate price. Mr Deputy Speaker, on behalf of the LNP, I would like to acknowledge Sue and Lloyd Clark. I'd also like to acknowledge the advocacy of Councillor Fiona Cunningham, who I know has worked very closely